session. Now we are getting into details with the law from the Human Rights Center and the Law School in Changsha, Central South University. And as usual, it's recorded, so I have to make you aware of this. We'll have a short presentation, and then we have hopefully a lively discussion. So I give you the floor from Xiaoyu. Probably wrong.
Xiaoyu.
The usual problem. Okay, so you have the floor.
Okay, I want to ask, the presentation time is limited or?
Sorry?
The presentation time is limited to 10 or 20 minutes or something else?
Well, it's not really limited in the strict sense, but if you have about, I don't know what you prepared, if we have about 10, maximum of 20 minutes, I would say.
Okay. So first I want to share my screen. Okay. Hello everyone, it is my great pleasure to attend this conference and to be among such distinguished scholars. My name is Xiaoyu and I'm assistant professor at the School of Law, Central South University. And today I will be discussing a critical topic, civil liability clauses in the CSDDD to retain or to abolish. And the CSDDD is Corporate Sustainability Due Diligence Directive. And on July 5, 2024, the EU introduced the CSDDD, which became effective on July 25. This directive is seen as the most ambitious CSR law to date, which its civil liability clauses being both innovative and controversial. But on February 26, 2025, the EU Commission released its long-waiting omnibus proposal designed to simplify the EU sustainability reporting and due diligence rules as reflected in the CSDDD, and including to removing the civil liability clauses. The changes in the legislation reflect the fact that the extensive of civil liability provision is highly controversial. First, let's talk about what is civil liability mechanism under the CSDDD. It's on Article 29 of CSDDD. It established civil liability for companies that failed to meet their human rights due diligence obligations. If a company neglects or intentionally breaches due diligence duties and cause harms, they can be held accountable for damages. Some scholars have called this mechanism a quiet revolution because it opens up new legal avenues for holding companies responsible for human rights violations. So I draw a picture. You can see that unlike traditional human rights litigation, where there is often no direct legal relationship between the victim and the head company of supply chain, Article 29 allows victims to directly sue companies for failing to meet their due diligence obligation. So there are divergent views on the retention and abolition of the civil liability mechanism. And the reasons for retaining are these reasons. Maybe because for preventing companies from shifting responsibilities through the supply chain, for enhancing victims' remedy, for ensuring real compliance with HRUG-LEGAL obligations, and bridging legislative differences across EU members. But the reason for abolish remains unclear. It is indeed quite unpractical that the EU's position on the civil liability provisions have changed drastically in 2 years. Maybe for geopolitical reasons and or for poorly designed rules or for corporate oppositions. No answers at this moment. So why the Global South need to care CS3D and its civil liability mechanism? I think there are three reasons. First, the CS3D has extraterritorial reach, impacting business and human rights in the Global South. Second, CS3D claims to improve human rights conditions in the Global South. And third, from the perspective of scholars focused on third world international law, there is concern that the EU is trying to assert itself as a global regulator leader. These scholars argue that the supply chain law of industrialized countries reflect a form of imperialist paternalism towards developing nations. They also worry that without proper international oversight, those with hegemonic interests may not have the best interest of the developing countries at heart. So my research focuses on one problem. Is the civil liability provisions justified? Is it justified on the basis of both substantive justice and procedural justification? And in fact, the reading of the main part of my article was completed before the EU published the proposal. It mainly adopted the position of standing for developing countries and criticizing the imperfectives in the civil liability provisions. However, the decision of the proposal to remove this clause in 2025 have a great impact on the writing of my essay. Because if this clause was eventually removed, it seems that my research had lost its object of critical. And before I start my next presentation, I also hope that everyone can help me to think together with the perspective of how to improve my research. So my research consists four main parts. You can see from this screen. The first part is about evolution and the institutional composition of civil liability. So the first part is about institutional evolution. I put it from two parts. And the first part is about international guidance, and the second part is about domestic practice. So in the international guidance, the first one is 2011 UNGPs. It established a three pillar. We all know that: protect, respect, and remedy framework. And the commentary to guiding principle 17 refers to the relationship between human rights due diligence and legal liability. It points out that HRDD should help business enterprise to address the risk of legal claims. However, the responsibility of business enterprise to respect human rights is distinct from the issue of legal liability, which remains largely a matter of national law in the relevant jurisdictions. And the second one is OHCHR. It published a report. We can know the name is here, and it point out the role of civil liability mechanisms in contributing to the fulfillment of HRDD by business. And the third one is UN Draft Treaty on Transnational Business Enterprise and Human Rights. Article 8 of the second revision of this draft treaty requiring states parties to establish domestic law to set on the principle that business failure to prevent harm caused by a third party may give rise to liability. On the whole, the international community has gradually deepened its understanding of the relation between HRDD and civil liability mechanisms, but the design of specific systems still need further improvement. On the whole, the human rights due diligence and civil liability mechanism at the international law level is more of a soft law. So the next part is about domestic practice. Of the many pieces of HRDD legislation, only the French Vigilance Obligations Act and the CSDDD have already introduced civil liability provisions. And according to the elements of the liability, I think there are four elements. First, the objective element is the enterprise failure to fulfill its HRDD obligation under CSDD, and the second one is the subjective element, the enterprise intentionally or negligence, and the second is about the result, the damage caused to the legal interest of a national person or a legal person that are protected by the state law, and the last one is about the causality. But the CSDD left this element to national law. So the second part, I focus on practical elements of the civil liability. I thought there are three elements. The first one is obstacles reviewed by judicial practice. We all know that the first law which introduced the civil liability is the French law. So there is already some practice, judicial practice, which can show the problem. And the second one, I think that this is normative defect barriers. So the CS3D's text is not so perfect. And the third one is the obstacles to capacity imbalance. So the person who are harmed and the companies, they have different abilities. So the first part is on what we can know from the French law practice. I already show a table here. There are 11 cases about the French law, but we can see the results. 4 is padding and 5 is inadmissibility on procedure grounds. So I think there are two different obstacles. The first one is about procedure obstacles, because most of the cases do not proceed to substantive hearing stage for procedural reasons. Gradually on the grounds that the plaintiff has not participated in the mandatory cancellation procedure. So under the Act, the plaintiff must give formal notice and must undergo a 3-month mandatory cancellation procedure before filing a lawsuit. So we can see on the table 5 cases is because of this reason. The next part is substantive obstacles. I cited the judge's opinion in this case, and the court noted that the duty to vigilance act did not clearly define the suspectives required to be met by this plan, and lead to a lack of clear standards of decision in judicial practice. So I think these are 2 reasons for the practice not going so well. So the second part is the text of CS3D is not so perfect. I think there is 3 reasons. So the first one is about the ambiguity in the standard of fulfilling the obligation of HRDD, centered on determining whether a company has taken appropriate actions in a particular situation. The UNGP has the UNGP do not make a clear distinction between the differences in situation in the cost, and another one is contributed to, and another one is directly related to. So it may lead to a lack of specific standards of judges in judicial practice, and the CS3D also didn't clarify that. The second one is too broad or a scope of the liability makes it impracticable for companies to fulfill their obligation in all. In contrast to French Village Obligation Act, the CS3D requires companies to be accountable for adverse HR impacts of a large number of business partners in their chain of activities, but the broad scope of responsibility makes it impractical. So the third one is the allocation of the burden of proof is unclear and difficult to accomplish. The CS3D leaves the question of burden of proof to the discretion of member states, although the CS3D does not specifically specify how the burden of the proof is to be allocated. Some member states are likely to place the burden of proof on the victim. So in this situation where important evidence of the fulfillment of HRDD by a company is often controlled by the company, it is difficult for the victim to prove the existence of the unlawful behavior, subjective fault, and causation. The third reason is about obstacles to capacity imbalance. So we all know that the victim vs the company, their ability, their money, and their time is different, and this will cause them very hard to sue and very hard to fulfill the burden of proof, and very hard to win the case. So, and the third part I focus on to jurisprudential rethinking of the civil liability mechanism. I also put this question into 3 reasons. The first is the difficult balance between innovative and normative natures of the law. The second is the conflict between the human rights of individuals and the right to development of business. And the third one is about extraterritorial effectiveness and the north-south governance gap. So the first one is about the law, how to balance innovative and normative. According to innovative civil liability mechanism have been innovated to address the shifting of human rights responsibility by transnational corporations through their supply chains, and the symbolic fulfillment of the corporate human rights due diligence obligations, and the inadequacy of remedies for victims. But at another way, the normative imbalance can be attributed essentially to the fact the HRDD legislation for supply chains is in the early stage of transition from soft law to hard law, and the exploratory natures of the private enforce model has been emerged as a result. Under this model, we all know that transactional corporates, which they are originally regulated entities, but now they transformed into regulators responsible for overseeing HR in supply chains. However, the traditional framework of human rights treaties is primarily directed at state, not business. And business are not states, so their logic of behavior, resources, capacity, and the scope of responsibility for business is in the fulfillment of their relevant obligations. So I think these two different values is not be balanced well in the CS3D. And the second part, I think there is the conflict between the human rights of individuals and the right to development of business. There are significant differences in the understanding of the relationship between individual human rights and the right to development of corporations between the Western world and the country of the global South. The Western world, most of them are very developed, so they may, in this stage, they focus more on the individual human rights, and the global South, they are still needed to developing, so they focus more on how to help their business or their companies to develop. And the harsh civil liability regime is intended to protect human rights of individual human. So, but to some extent, inhibits the right to development of business. CS3D has been assessed as likely to undermine the legitimate interest of business to operate freely and to weaken the market competitiveness of the EU business. And the third one, I focus on the extraterritorial effectiveness and the North-South governance gap. So the extraterritorial effect of CS3D not only puts a potential threat to the sovereignty of other states, but may also violate the notion of fairness and the North-South equality. Although the CS3D itself is an extraterritorial piece of EU law, it has undue extraterritorial effects through the control of the subsidiaries by their parent companies and pass-through effects of the supply chain. So the extraterritorial effects of human rights due diligence legislation ignores the significant gaps in governance capacity, levels of economic development, and the legal systems between countries in the global South and North. And the four parts, I focus on how to improve the civil liability mechanism under the CS3D. The first one is about So the first one is about revision of the law to enhancing the balance of the legislation. And the second one is about the flexible justice, ensuring the appropriation of penalties. And the third one is about functional positioning, clarifying the boundaries of the civil liability mechanisms. So the first one, I think CS3D need to clarify the criteria for the fulfillment of the company's obligation, narrow the scope of the due diligence obligation, and establish a fair and a clear systems of the burden of the proof. And in the other way, they need to strike a balance between relief for victims and the compliance burden on companies. The second one is I think it should ensuring the proper of penalties. Mandatory HRDD legislation should be viewed as a mechanism for guiding continuous learning and improvement rather than a mere punishment instrument. And HRDD legislation should move from a punishment orientation towards a more participation and learning-based nature, encouraging business to remain in the relevant market and take their HRDD obligations seriously rather than opting out to avoid uncertainties and risks. And the third one, we should clarify the boundaries of the civil liability mechanism. CS3D has constructed a diversified regulatory framework, and including Article 14 grievance mechanism for enterprise and administrative oversight mechanism and the civil liability mechanism. So I think the three different mechanisms both need to work together. We cannot just put all the effort to civil liability. So that's my presentation. Thank you.
Well, thanks very much.
Sorry, my English is not so good.
It's perfect. There's actually today no native English speaker amongst us. Yeah, thanks very much. It was very interesting. Now I have questions for about 2 hours. But I'll open the floor if anybody has questions, please.
I think I had a question.
Yeah, go ahead.
Okay.
I was going to ask that, yes, I think this is a very important step in order to better realize the conducting of human rights in international. But the question is, I don't think I am quite persuaded in how the UN itself is going to enforce this upon international companies that operate on many different states and not just one. How are they going to enforce it, their obligations, and how are they going to enforce justice, for example, punishment for offenses?
Actually, I didn't understand this question.
I said, how are the authorities going to enforce their punishments or obligations upon international companies in practice, not just in paper?
The CS3D, which require the EU members to enact domestic law, and then the victim can sue in the domestic court, and they can get the pay. So this is the way how they make this law and the civil liability to real world. So my answer is it's to your question. It's okay.
Yes, it's okay. Thank you.
Sorry.
Thank you.
Well, linking to this question or giving a little bit an answer to it from a different perspective, there had been, I don't know, this week, the European Union against Meta and Apple, I think, in that were competition law. But I think what you address is actually a political will. It's not so much the question if it's possible or how to implement it, but it's more a matter of political will. And now the European Union wanted, and this was not least linked to the tariff conflict, and before they didn't do anything. So I think in this case it's very much the same. If they want the authorities, now the question would be who are the authorities at the end? But if they want, there is a way. But they have to want. That's, I think, the main problem. Ochan, I think. But, yeah. I can't hear this. Can the others hear?
No, I can't hear.
No. But now your microphone is muted anyway.
I was trying on the test mode.
Yeah.
Perfect.
Sorry for the technical difficulty. So I have a rather interesting question, in my opinion. What do you think in terms of the practice that companies actually employ in this issue? Because I know for a fact that being in the business, that companies move their products through other channels and other means and rebrandings in order to avoid these issues altogether. And this costs money to the companies, of course, but it is rather a smaller price, and these prices are coming from the ends of the customers in general. So in this practice, what do you think should be done in that regard?
Okay, so I listened that you told the companies may choose to leave the market, not and not to fulfill the obligation, and you ask how should I think this question, right?
No, what I meant is, for example, let's say a company from Congo is importing a good, but they don't want to cooperate with these laws. So they produce the good, but they move it to somewhere else and rebrand it, and as if the production wasn't in Congo and it complied with the rules. They try to avoid the rules by these means. So how do we monitor these issues, and how do we deal with these issues?
So actually, that's the reason why CSDDD wants to set the civil liability. They set the HRDD obligation. They need to make a report every year. The human rights damages they caused or their other partners caused in the supply chains. They need to report it, and if the damage is caused by the other partners in the supply chains, the head of the supply chains, they need to responsible for the damages. So I think this is the reason they set the civil liability mechanisms. But in real world, I don't know it will work or not.
So in the real world scenario, the issue is that if the company is responsible for reporting, they are just not going to report you if the report the issue if the punishment is too harsh, and if the punishment is not too harsh, or if the punishment, if the reporting due diligence goes to the government or a third body, they are not going to be effectively be able to detect the issue because the company doesn't have to really report the things they are doing. They are in the private sector, so they can do it in an undetectable manner. So there's not a practical issue for the on-site problem.
Okay,
How do we deal with that?
Yes, it's questionable, and but the CS3D is the most ambitious law in the HRDD aspects. So if CS3D cannot resolve these questions, I think no other laws in the world can resolve these conditions.
Mehmet?
Thank you, Ms. Xiao.
Okay. One moment, I will lower my hand. So first of all, thank you for your presentation, Fan. I have a question particularly related to Olan's question. Are there any empirical data or research information, let's say, about the feedback of the business of the corporations? So, and what is the network of working together? So the actors, the state on the one side, the legal actors, and also the corporations. How is this? This must be also internationally organized somehow in a certain common way. Is there any? I think is there any progress in this standardization of these networks for working together? Do we have any information about this?
You are asking, is there any other progress in this question, right?
Not any other progress as such, because we have different actors who have to work together. As I said, the state, global networks, corporations, legal scholars, etc., politicians. Is there any developed network organization trying to structurize these things, or is this still not a question which is handled? Do we have information about this? Because you spoke a little bit about legal dimensions, but going beyond, beyond this dimension, are there any other attempts to do so?
You are asking, is there any different dimensions of the lawmaking, not just the EU and any other countries?
I asked, I asked if the network of actors is now globally tried to be organized together. So how can we say, as I said, on the national basis, on the international basis, the different actors having to theorize and practice this thing, what you mentioned, the liability clauses, which should protect human rights and things like this. Is there any attempt globally to do this on a practical level, going beyond legal definitions or legal conceptualizations? Okay, if not, because your perspective is, of course, because you are in this field, is a little bit legal perspective. But it has to go beyond. As Ozan also said, there is a problem of voluntarity, of willingness, of political things. Is there any network to bring all these things together?
I didn't see any other things, so I can't give you a good answer to this question.
Well, I think part of the answer you gave actually when you showed the table with the different companies in France, although I thought there was one Italian from the name. But this is a legal perspective, of course, Mehmet, in this area.
Yeah, I know.
But
I wanted to know if fun has also other
hang on.
dimensions.
There is a transnational network. It's actually not what you have in mind, bringing things together, but a kind of observatory. I don't know the name out of the top of my head now, but they are trying to make aware of it. You have as well Amnesty International or organizations like this. I think what is important in this case is really looking at France, because what you have there is a strong movement, especially against some of the large international corporations. In this way, I think this is part of the answer. But as far as I'm aware of, there is no systematic approach, and this would be actually something for the United Nations to build up. United Nations, one of the bodies, to build up an observatory like we have in actually on the European level as well, against competitiveness, dealing with this and being obliged to have a kind of reporting on the issues, not coming from the enterprises themselves, not coming from the governments, but a kind of neutral observatory. Difficult to get into place, but I think there is some progress made over the last 2 years or so, coming back to actually, so it's longer, coming back to one of the commissioners who had been really engaged in it, with it, although it had been limited against to competition. But this is one of the most important areas, I think, to put competitiveness actually on the second level, and to say human rights are more important, and human rights in the widest understanding.
Yeah.
So this is from my experience.
Okay, I'm aware of what you said. I imagined this also by myself. I only wanted to, it's clear now. It was clear for me. I had the same answer in myself, but I wanted only to ask Sven. There is more additional insider information from a person like Sven, who is narrowly inside this topic. This was my question, but okay, it's now. It's okay.
Ozan?
So the reason why I asked the question is that I spent a little time in a logistics company, and I had on-hand experience with the international trade in practice. So there are a lot of different issues to address in terms of the legal boundaries. Like, for example, we cannot even agree on what a certain good is in between different countries, even if they are inside the Europe. That's the sort of the issue. There is something called customs tariffs statistics positions, which is the number given, identity code basically, given to the goods that have been produced. And we can't even agree on what certain goods are. Like, same good can be identified as something else between Italy and France. How are we expected to monitor the human rights issues in the production of the good when the rules themselves are applied based on the goods and we cannot agree on what the good is? So there's a lot of scrutiny there, and we need to revolutionize the tariffs and international trade altogether before addressing this issue, in my opinion, in terms of the legal standard. That's why I was asking the question.
Steve, now you can unmute your microphone.
Yeah, I just wanted to make some comments also, if possible, briefly, because the discussion, I think Fang was mentioning the idea that there are certain obstacles in her presentation. For example, geopolitics, the role of the difference in perspective, which we get from, let's say, the global south, the developing countries, including in that sense China, and what we have normally called the so-called developed sector, European side of things. And I mean, that's clearly a factor because the question of sovereignty comes up even in the role of the United Nations and the issue of human rights in general, because can you actually implement the decisions that the UN has made? For example, in the question of what Israel has been doing in Gaza, where the power of the Israeli state ignores, together with their supporters from the United States, a position that even generally is acknowledged and supported by the UN in general. So you get this dilemma of national sovereignty versus international institutions, even in the case of the UN and the issue of human rights, which is a problem. And I think it comes up even in light of the topic of corporate responsibility. That also implies most corporations have a certain base of operations, which is out of a certain national, a certain nation state. And the position of the nation state implies directly what they will, for example, accept or not accept, even in light of what decisions might be coming out of human rights decisions in the UN. That's a big problem. But there's an underlying fact that I wanted to just put on the table to think about, because there is a factor. Without going into details at this point, I could do it at another point, around what is called natural law, as defined in the best sense by certain thinkers like who I'm familiar with, Gottfried Wilhelm Leibniz, versus what has been called positive law. And the essence of natural law is the idea that there are universal standards which shape or should shape the direction of justice, of what is actually can be considered justice, or what is the difference between what is right and wrong. Positive law tends to ignore that and operate on the basis of ethical standards or written bureaucratic laws, which are not always in harmony at all with what you might call higher law or universal natural law. And this issue, although it's not generally addressed, in my view, has great significance on this question of human rights in relation to corporate standards, but it also has relevance in general as to under which premises nation states and even corporations are operating. And do we, as an organization promoting human rights, can we address this from that position of what I consider to be a proper position, that there are universal concepts which define justice that are not simply based on arbitrary, either bureaucratic or positive laws that might be adopted. Now, it's a complex question or issue. I understand that, but I think the question of which notion of law you operate under has a major impact on how you look at these and resolve these questions of human rights, even in this context of corporate responsibilities.
Well, we have to come to an end. Mehmet, finally, on the question of natural law, just a remark, the Pope is dead, we got a new one. Mehmet, your last word,
Yes.
so to
I will be short. I will be short. Only a concrete question to Fan again. You spoke of 3 dimensions of solutions, let's say dynamic, revision, flexible justice, etc. I want to ask you only this flexible justice thing. Huh? I mean, if it comes to the responsibility of corporations, don't you have to be not flexible, a little bit but on the contrary, don't you have to handle out certain forms of let's say punishments in quotes against these corporations? So I didn't exactly understand this flexibility in this context means. Does this flexibility not give too much? How can we say free space for possible non-ethical actings of corporations? Do you think?
Okay. So your question is about the flexibility, right?
Yes, the flexible justice thing, the second point, what you mentioned in your presentation.
Yes. What I say in the flexible justice, I'm saying the rules of the civil liability in the CSDDD is very strict, and it's more like a punishment to the company. But I think the HRUG-LEGAL legislation should be viewed as a mechanism for guiding continuous learning and improvement. And I think this the lawmaking of the corporates about HRUG-LEGAL is only on the first stage or only very earlier stage. So too strict civil liability clauses is not very appropriate. So I think HRUG-LEGAL legislation should move from a punishment tools to a tools more participatory and learning based natures. So basically, I think civil liability clauses to be made now is not good. So that's what I want to.
Okay, thank you.
Okay.
Okay, thanks very much. I think we could go on for a couple of hours, and we definitely have to take this up again in different areas, because it's increasingly an issue with the multinational corporations, with especially the digitalization, artificial intelligence coming up there, and the issue of tariff politics. So thanks for now. We have another open talk on I think it's on the 30th of May, last Friday of each month, as usual, and this will be recorded and at some stage available on YouTube. Thanks very much, especially to Fan and all others, and all the best to you. Thank you.
Thank you.
Thank you.